All right, welcome everyone to Consumer Law 101, sixth video in our advanced video series. This one is entitled The ABCs of the FCRA Part 3, Common Credit Reporting Violations. As always, I'm your course instructor, Attorney Aaron Swift. I am the Swift Law North LLC CEO and Managing Partner. We're going to talk about today in our common debt collection violations, common violations by the credit reporting agencies, common violations by furnishers, and then consumer best practices. Okay, so there are a couple of subsections of the Fair Credit Reporting Act that regulate credit reporting actions, credit reporting agency actions, and therefore they can violate several subsections. So the first is just simply a credit reporting agency's failure to follow reasonable procedures to assure the maximum possible accuracy of credit reports. That's called an EB violation. So what that requires is first an initial showing of an inaccuracy, incompleteness, or inconsistency, and then you have to show that the CRA failed to follow reasonable procedures. Then after dispute, or excuse me, after a mistake, error, inconsistency, or inaccuracy has been identified, and then if a consumer disputes to the credit reporting agency, then there are a whole bunch of other types of violations that happen under subsection I. It's failure to properly investigate, failure to review all information, failure to provide dispute results, failure to include a consumer's 100-word statement, and there are a couple of others. Then there are subsections that protect specific identity theft and fraud instances. That's a subsection, unfortunately, that's abused a lot. You can learn more about that in some of our other videos about common myths and lies told in the credit repair space, um, particularly when things are fraudulently disputed as fraud, for lack of a better way of putting that. That's a really big no-no, but it happens too much in that space. But nonetheless, if there's a valid instance of identity theft and fraud, and the CRAs are put on notice appropriately, and they fail to block that information, fail to provide notice to the other agencies, that's a problem. So again, these are common credit reporting agency violations, but always understand you're going to start from the position of there has to be a material inaccuracy, an error, a mistake that's material, and go back to the standards. Is it a technical accuracy but a material misleading instance, or is it just an objective inaccuracy, something that's just plainly wrong? And then the CRA may have violated one of these subsections by, engaging in some of these common practices. All right, the FCRA, excuse me, does not have an equivalent section against furnishers of information. In other words, you cannot bring a lawsuit against the furnishers for an S2A violation, which would be the equivalent to an EB violation. There's no cause of action under S2A. And so what that means is the violations that you can bring against a furnisher, that those are the companies that furnish the information, remember. That's why we design these curriculum series to build on themselves. Go back to the Who's. We're talking about furnishers of information. These are the credit account, trade line named parties, first creditors or current creditors for junk debt buyer situations, or these are collections trade lines. Those are all furnishers, or it could be public record furnishers, public information furnishers. Um, Again, it goes back to who is providing the information. For them to violate the statute, you must first dispute. You have to dispute. You cannot sue a furnisher for violations of the Fair Credit Reporting Act if you don't dispute first. And even more important, those disputes, they have to go to the bureaus first, to the CRAs first. You don't just get to dispute directly to the furnishers and that trigger liability. Again, there are more videos later on in the series about the powers of those statutes, how to use the both the FDCPA and FCRA as, leverage when your rights have been violated. But in this instance, under the FCRA, you must dispute first in order to sue a furnisher. There are a couple other user violations. If a user is using a credit report impermissibly, there are some crazy cases like car dealership finance managers pulling credit reports of their exes, to spy on them. That's of course, a privacy violation. Um, After a bankruptcy, accounts that have been discharged no longer should be performing account review inquiries, even soft inquiries, because that relationship has been extinguished based on the bankruptcy. So Those are common violations, mainly by furnishers and some by users. But again, these are going to be things that you're going to be looking for in terms of your consumer best practices. Hopefully now you've understood the who, what, and why of the FCRA, its common standards and terms, and now you can apply those to their actions. Consumers can fight back. Remember, there's a private right of action under the FCRA, just like the FDCPA. You may be entitled to not just a clean credit report. That's step number one, fix the problem, but potentially thousands and thousands of dollars in damages. And again, the FCRA provides, just like the FDCPA, that the attorney's fees and costs are paid by the defendants, by the bad guys. For more educational content, we invite you to please reach out to consumerlaw101.com. And for litigation answers, in particular, if you think there are errors on your credit report, certainly errors that have caused damages, if you've been denied loans, been denied an apartment, denied a job, or insurance, let us know. We'd love to at least perform a review of your credit reports to see why and why it happened and if there were errors that could have contributed. So again, www.swiftlawnorth.com. Thank you.